Welcome back to the Deep Dive. Today, we are really getting into the weeds on contracts. What does it actually take to form one?
That's right. We're looking at the absolute basics needed for any agreement to hold up in court.
And our mission really is to test that old saying, that everyone is equal before the law. Does it actually hold up when you look at who can make a binding deal?
It's a great question because, look, to enforce an agreement, say sue someone if they break it, you need the big three pillars: agreement, consideration, and intention to create legal relations. We'll touch on intention later.
Right.
But even before that, the parties involved, they need to have a legal identity. They need to be persons in the eyes of the law, and they need the capacity to be bound.
Okay, let's start right there. Legal identity, legal personhood. That sounds fundamental.
It is. It goes way back. Think ancient Rome. It's basically the concept that grants you rights, like the right to go to court or the right to own stuff, property.
And it's not always straightforward who or what counts as a person.
Not at all. That's what's so fascinating. The legal definition is, well, flexible. It's definitely not always been tied just to being human.
How so?
Well, historically, some humans weren't considered legal persons, unfortunately. And conversely, we give legal personhood to things that aren't human at all. We call them artificial persons.
Ah, like corporations.
Exactly. Corporations are a huge example. But it goes back further. Think medieval monasteries or nunneries. They needed to own land, right? So the law sort of created a legal shell for them.
So they could act like a person, legally speaking.
Precisely. And today it's corporations, ships, even religious idols in some jurisdictions. They can have rights and, importantly, obligations.
Okay, this is where it connects to today, especially with technology. If being human isn't the only requirement, where does it stop? People are talking about animals now, and definitely AI.
Oh, absolutely. The debate is heating up. You get these slightly weird situations, like remember Rocco the parrot back in 2018?
Vaguely. He ordered things online.
Yeah, using his owner's Alexa or something. Ordered snacks, light bulbs. The owner had to pay, obviously. But it sort of ridiculously highlights the question, who can act in a way the law recognizes?
And with artificial intelligence, it's less funny and potentially much more serious. We have basic AI now. Smart assistants, maybe.
What some call weak AI. It follows instructions.
Right. But what about strong AI? AI that might actually create.
Right, that's the frontier. Look at AI art generators. You have artists like Mario Klingman who use AI like an instrument, he says. But what if the AI genuinely creates something original, copyrightable, without that direct human input?
Who owns the copyright then? The human, the AI.
Exactly. If the law says the AI could be the creator, you're essentially giving it a property right. And that's a massive step towards legal personhood.
Which brings us back to humans. If you are a legal person, can you always bind yourself in a contract? Let's talk capacity, starting with minors under 18s in England and Wales.
Okay, so the law here is very protective. Generally speaking, a contract made by a minor, it's not binding on the minor.
But it is binding on the adult on the other side.
Yes, it's what we call voidable. The minor can choose to get out of it, but the adult can't force them to stick to it if they want out.
That seems unbalanced.
Yeah.
Deliberately so.
No, completely deliberate. It's about preventing exploitation. But the law isn't naive. Minors still need to, live. They need to buy things, get jobs sometimes.
So there must be exceptions.
There are two main ones where a minor is bound.
Which are?
Contracts for necessaries and contracts of beneficial employment, or things like apprenticeships, education, service contracts that benefit them.
Okay, necessaries. That sounds a bit old-fashioned. Is it just like bread and water?
Oh, no, it's broader than that. It means articles purchased for real use. But, and this is key, it's judged relative to the minor's age and their station in life.
Station in life. So what's necessary for a rich kid might be different from a poorer kid.
Pretty much, yes. It's context-dependent, and it gets tested by modern life.
Like that gaming case. Take-Two Interactive.
Exactly, the 2020 case. A minor was sued for breaking the rules, the EULA, of an online game using cheats.
And the company argued the contract was binding.
Yeah, they argued access to the game, specifically the online multiplayer part, was unnecessary for a teenager today.
Did the judge buy it?
The judge was pretty skeptical, questioned whether a digital service, not physical goods, could really fit the traditional definition of a necessary. It shows the definition is under pressure.
Okay, what about the second exception? Beneficial employment.
This is about allowing minors to start earning a living, but again, with protection. The contract has to be on the whole for their benefit.
Is there a famous example?
The The Wayne Rooney case from 2006 is a classic. When he was about 15, he signed with Everton Football Club and also signed a deal with an agent.
Okay.
The court said his contract with Everton, binding. It was beneficial employment, essential for his career.
But the agent contract.
Not binding. The court decided it was sort of extra, not essential to him actually playing football and earning a living at that stage. It shows the courts really look closely to see if it truly benefits the minor overall.
So just to quickly clarify, these minor contracts are generally voidable, meaning valid until avoided, not void like they never existed.
Correct. Void means it's a nullity from the start, no rights pass. Voidable means it's valid unless and until the minor takes steps to cancel or rescind it. Big difference.
Got it. Okay, huge protection for minors then.
Yeah.
Let's switch gears. What about capacity issues related to mental impairment? How does the law handle that?
Now this is where things get much, much stricter, and where that idea of equality gets really complicated.
How so?
The standard test, it comes from an old case, Imperial Loan Covey Stone back in 1892. It's a two-part test, and the burden of proof is on the person claiming incapacity.
Okay, what do they have to prove?
First, that they actually were incapable of understanding the contract at the time they made it, and second, this is the tough part, that the other party knew about their incapacity.
Wait, me about it. So if the other person genuinely didn't realize the person had an impairment, the contract stands, even if the person was incapable.
That's the traditional rule, yes.
Wow. Compared to minors where the contract is automatically voidable unless proven beneficial, that's a massive difference. The burden is entirely flipped.
It's a huge difference, and it stems from that tension we mentioned, protecting the vulnerable versus ensuring certainty in contracts. If anyone could just claim later they didn't understand, commerce would grind to a halt. The law prioritizes predictability here.
But is that rule softening at all? Is there any movement?
There might be. It's interesting. Baroness Hale, in a case called Dunhill v. Burgeon in 2014, she sort of floated the idea that maybe the test should be broader.
Broader how?
She suggested maybe it should be whether the other party knew or ought to have known about the incapacity.
So introducing constructive knowledge, like if there were obvious signs, you couldn't just ignore them.
Precisely. That would lower the bar somewhat and offer more protection. But even with that potential shift, it's still way harder for someone claiming mental incapacity to get out of a contract than it is for a minor.
Okay, this leads to another difficult area. What if the vulnerability isn't mental impairment, but something like illiteracy or not understanding English well? There was a case about this, wasn't there? Barclays Bank v. Schwartz.
Yes, 1995. And the judge, Millet LJ, made a really critical and, frankly, quite controversial distinction.
What was the distinction?
He argued that conditions like severe mental incapacity or even extreme drunkenness, they don't just stop you understanding the deal. They stop you realizing you don't understand. You lack insight into your own limitation.
Okay. But someone who can't read or doesn't speak the language.
Millet LJ said that's different. If you know you're illiterate or you know you don't understand the English document you're being asked to sign, you are aware of your limitation.
And if you sign it anyway?
Then, in his words, you have only himself to blame.
That sounds incredibly harsh. Almost like blaming the victim. You're vulnerable, you sign, and it's your fault.
It does sound harsh, but the reasoning behind it was arguably pragmatic, though you can definitely debate its fairness. It was a policy decision.
What was the policy?
Millet LJ was worried. He feared that if illiteracy or poor English became an easy way to escape a contract, then banks, lenders, businesses, they'd just stop dealing with people who weren't fluent English speakers or readers.
So he thought it would actually harm immigrant communities, for example. Make it hard for them to get loans, mortgages, things like that.
That was exactly his concern. He argued that enforcing the contract, even if harsh in individual cases, was better for the community overall because it kept the doors open for them to participate in the economy.
So it's a really difficult balancing act. Protecting the individual versus potentially hindering a whole group's economic access.
It's a stark choice the law made there, prioritizing the stability and accessibility of the system, arguably over individual fairness in specific hard cases, provided the person knew they didn't understand.
Okay, so even if you have legal capacity, there are other barriers, practical things that stop people really having freedom to contract. Accessibility issues.
Definitely. We can think of maybe three big ones. There's financial exclusion, just not having the money or credit access to even participate in many contracts on fair terms. That cuts huge numbers of people out.
Right. Obvious but crucial. What else?
Then there's the problem of jargon and legalese. Contracts are often written in dense, impenetrable language. Even highly educated people can struggle to understand exactly what they're signing.
Yeah, you almost need a lawyer just to read the terms and conditions for a phone app sometimes.
Exactly. And the third big one, increasingly, is the digital divide. So much contracting happens online now. If you don't have reliable internet access or the digital skills, you're locked out again.
With the legalese point, are there any solutions emerging?
There are some really creative ones, like the visual contract or comic contract idea championed by a lawyer named Robert DeRoy.
Comic contract, like with pictures.
Yeah, using images, icons, simple layouts instead of walls of text. It's been used effectively, for example, with fruit pickers in South Africa, where workers might not be literate in the language the main contract is written in. It makes the terms much more accessible.
That's genuinely innovative.
Yeah.
Okay, let's bring in that final piece we mentioned at the start. Assuming you have capacity, the contract is accessible. You still need intention to create legal relations, ICLR.
Absolutely vital. This is basically the law's filter system. It stops the courts getting clogged up with every casual promise or social arrangement we make.
Like agreeing to meet a friend for coffee or giving someone a lift.
Exactly. We make agreements all the time, but we don't intend for them to be legally enforceable if someone breaks them. ICLR ensures the law only steps in when the parties genuinely intended their agreement to have legal consequences.
And the courts have developed shortcuts for this.
Yeah.
Presumptions.
Yes. Two main starting points. They're rebuttable, meaning the facts can overturn them, but they give a default position.
Yeah.
First, in domestic or social arrangements, agreements between family, friends, partners, the presumption is you do not intend legal relations.
Okay.
Second, in commercial arrangements, business deals, the presumption is you do intend legal relations. And it's quite a strong presumption. You need pretty clear evidence to argue a business deal wasn't meant to be binding. That came from Edwards v. Skyways.
But these are just starting points. The actual facts can flip the presumption.
Totally. Context is everything. Take the domestic one. There was a case, Kukukoilu v. Oscan, in 2014. Two friends regularly bought lottery tickets. They explicitly agreed if they won, they'd split it half and half.
And they won.
They won £1 million. One friend tried to keep it all, arguing it was just a casual chat between mates. But the court said no. The explicit agreement to split it showed clear intention to be bound, overriding the usual domestic presumption.
So the specific words mattered more than the friendly context.
Absolutely. And it works the other way, too, with the commercial presumption. Think about family businesses. In Johal v. Johal from 2021, 3 brothers were negotiating a buyout of part of the family business. It was informal, between family members.
So you might think domestic, no intention.
You might. But the court looked at the subject matter a significant business transaction. They said the context was predominantly commercial, despite the family ties and informality, so the commercial presumption applied and the agreement was binding.
So wrapping this all up, that idea of equality before the law in contracts looks, well, pretty shaky when you dig into it.
It's complex, isn't it? You have these layers. Who counts as a person? Who has capacity? And the rules are very different for minors compared to someone with mental impairment or language issues. Then you have accessibility barriers. And finally, this need to prove intention.
It seems the law is constantly doing this balancing act.
It really is. Protecting vulnerable groups like minors is clearly a priority in some areas. But then, as we saw with mental incapacity, and especially with the reasoning in the Barclays case about illiteracy, the need for predictable, stable contracts for the sake of the wider economy often takes precedence.
Which leaves us with a final thought for you, the listener. We've seen it's much harder for someone claiming mental incapacity to avoid a contract than it is for a minor. And we heard the argument that making language barriers a defense could actually harm immigrant communities by restricting access to finance. It forces us to ask a really tough question.
Yeah, where should the law draw that line? How much should it prioritize protecting the individual who might be vulnerable in a specific transaction versus ensuring the stability and, paradoxically, the accessibility of the contracting system for society as a whole? It's a constant tension with no easy answers.